Welcome back to Organized, the business law breakdown. I'm Professor Seth C. Oranburg, and I'm pleased to introduce a new season. And this season, we're diving into corporations. The corporate form is the entity type that shapes economies, defines industries, and sometimes collapses spectacularly in a blaze of legal battles. And before you think we're going to go on a deep dive into soulless corporate giants, this isn't a TED Talk on synergy. We're going to talk about why corporations exist, why society makes the trade-off that allows them to have their limited liability at the rest of our expense, what makes them work, and why corporate law, specifically Delaware corporate law, rules the game for now. So to do that, we need to start with a simple but fundamental question that will motivate this entire season of learning. Why do corporations even exist? A corporation isn't just a business. It's a particular type of business or firm. It's a legal entity, and it stands apart from the people who run it or who invest in it. It's not the same thing as the people that comprise it. So what makes this corporate form the most dominant business form in the modern world? I've identified three features that I think are the most important: limited liability, perpetual existence, and specialized management. Let me explain all three. Limited liability means that investors in corporations, owners, can't lose more than the money they invest. They can lose all the money that they put into purchasing the stock, but creditors can't take your house, your car, or your collection of action figures. Your risk is capped at what you put in, making it a safe way to take big swings at business opportunities. Second is perpetual existence. Corporations don't die when their founders die. Corporations can exist indefinitely, meaning they can outlive their original owners. IBM was founded in 1911, and everyone who founded it is dead, but the corporation has gone from punch cards to artificial intelligence in the meantime, and could last another 100 years. They can also outlast economic cycles, and so it's a pretty good place to park money for the long term, allowing them to be stable ways to make long-term investments, which can result in huge productivity gains. And third is specialized management, the separation of ownership and control. This is a big one. Unlike partnerships, where there's a flat structure, shareholders own the company but don't run it. Instead, they elect a board of directors who oversee corporate leadership, which then hire executives who hire employees to handle daily operations. This hierarchical structure allows for professional management, reducing inefficiencies and enabling companies to scale massively. Although, of course, it does cause some of the agency problems we discussed in our previous seasons on agency cost and in our economic analysis of agency law. And, of course, corporate law steps in to solve those problems as well. One place solves them particularly well, which is Delaware. And we'll come back to why Delaware is the dominant area for this dominant form of business. Anyway, these three elements, limited liability, perpetual existence, and specialized management, explain why corporations are the dominant business form. They reduce risk, increase stability, and allow for professional scalable management so you can have long-term investments in huge projects that can span generations. Now that we know what makes corporations special, let's talk about who makes the rules about corporations. Because unlike securities law, which is largely federal, or contract law, which comes out of the common law system, corporate law is state statutory law. You see, when you incorporate a business, you don't go to federal Congress, at least not yet. There's occasional talk about the federal government getting into the corporate game, and that should make Delaware nervous. But for now, you get to pick any state in America. In fact, you can also incorporate abroad, and you get to file with the state whose laws you want to govern your company. It's called the Internal Affairs Doctrine, and by choosing where you want to incorporate, you choose what law governs your internal affairs. Now, sometimes the choice is easy. If you're running a small family business, a pizza shop in Pittsburgh, you might incorporate in Pennsylvania. But if you're taking your company public on the NASDAQ or the New York Stock Exchange, there's a really good chance you'll incorporate in Delaware. Why? Delaware is tiny. It's America's second smallest state, second to Rhode Island. It's famous for basically two things: a bridge to New Jersey and Joe Biden. I'm kidding, of course. It's famous for the bridge and for corporations. But despite its size, over 60% of Fortune 500 companies are incorporated in Delaware. Why? Well, it must be that they see some value there. And so we can assume, based on how the market acts, that Delaware corporate law is perceived as the gold standard. What does it offer that companies want? Well, predictability. Decades, in fact, over a century of case law means businesses know what to expect. And in fact, Delaware updates its law to be more predictable over time. Efficiency, meaning the Delaware Court of Chancery, they specialized court. So when there's a business dispute, you don't have to worry if you're going to get a judge who understands business or doesn't. And you don't have to worry about a jury. Cases move fast, and the judges all understand corporate law because that's what they are hired to do and what they do all day, every day. And third is flexibility. Delaware gives managers wide latitude in structuring governance. They usually choose to have fewer, what we'll call fiduciary obligations, which means fewer governing headaches and fewer reasons shareholders can sue. Now, not everyone thinks this is a good thing. Some people think this system creates a race to the bottom, that this ability to incorporate anywhere means that states who want money from franchise taxes from the corporations that choose to be there will make state law which obviates all fairness to shareholders. And this argument has some merit, because if you look at Delaware, it doesn't have very robust shareholder protections. But shareholders can decide whether they want to invest in a company or another, and they keep deciding to put their money in these companies, which suggests that it might be a race to the top, where states are competing to create the most efficient, the most business-friendly laws, which benefit everyone. So which is it? Is this a pro-shareholder, pro-management paradise that has optimized the trade-offs? Or is it a corporate playground where the CEOs that make the big decisions like where to incorporate anyway take advantage of everybody else? It depends on who you ask, and it's worth remembering before you try to answer that question that most investors are not you and me. They're huge institutions as well, who are probably able to take care of themselves. We'll tackle that debate in a later season, especially as we talk about corporate governance. But this season, we're going to break down how corporations work, who's in charge of them, and how the law regulates or fails to regulate corporate power. We're going to focus on Delaware and also look at the Model Business Corporations Act, because that will tell us basically how corporate law functions across America and with the largest corporations in our focus. In the next episode, we're going to get into the corporate charter and bylaws, the DNA and birth certificate of a corporation, if you will. If corporations are legal persons, and they are to some extent, although they can't vote, they do have legal personhood, and these are their rule books that govern how they go about their lives. So until then, remember, if you feel overwhelmed by corporate law, just remember, you can look it up in a book. It is based on statute, and it's all founded as a matter of statutory law. And one of the reasons people prefer Delaware is that not only do you have a clear statute that keeps evolving to meet the needs of businesses, but you have 100 years of case law that answers most questions that come up in traditional corporate forums. We'll go through it all in this season. Until then, I'm Professor Seth C. Oranburg, and I'll talk to you next time.